Hi, everybody. Welcome to Clinic's webinar on TPS beneficiaries and authorized travel following the rescission of matter of ZRZC. We are really excited to talk about this recent development. It's positive news that I think is going to be helpful for many TPS beneficiaries who otherwise have some path to permanent residency, but just need this opportunity to travel and become eligible for adjustment of status following that authorized travel. So over the course of this next hour, we're going to cover what the new policy guidance means for TPS beneficiaries who might be seeking to travel abroad through authorized travel, or who may have traveled already in the past via advanced parole. So let's just introduce ourselves really quickly. My name is Alyssa Mira. I am a staff attorney with Clinic based in Southern California. I train on a variety of different immigration law topics, including temporary protected status. I'm very happy to be here, and I'm very happy to be joined by my colleague, Jen Riddle, who is a senior attorney at Clinic based in Asheville, North Carolina. Hi, Jen.
Hi, Alyssa. Hi, everybody. Thrilled to be here with all of you today.
All right, so just a couple of notes before we move on. If you have any questions for us throughout the presentation, please type them into the Q&A box. We are going to be going through some examples later on, and we might ask your feedback. And in that case, we'll ask you to type into the chat box. But if you have questions for us, please type it into the Q&A box. And let's take a look at what we're going to be covering today. So here's our agenda. We're going to be reviewing the new policy guidance to better understand what its significance is, who it applies to, when it's applied to past travel. We're going to be talking about how exactly authorized travel can help a TPS beneficiary overcome a past entry without inspection in order to meet the requirements of adjustment under 245A. So we'll discuss 245A a bit as well. We will talk about some issues that are related to inadmissibility, in particular, the grounds that are related to prior removal orders and how travel might affect that. And then we'll look at some other considerations related to prior unexecuted removal orders, how you can apply for travel authorization, and we'll leave you with some practice tips and other considerations. So we're about to dive in. Before we do that, let's just take a look at what exactly we're going to be referring to here. So there are two new sources of this policy that we will be looking at. So first is what we're going to be referring to as the policy memo that announces the rescission of matter of ZRZC. This was issued on July 1st, and you'll find some information there that provides a lot of helpful background to this issue, some reasoning behind the current policy change, and of course the details about what the agency interpretation is going to be going forward. And then the USCIS policy manual has been updated with respect to how this the new policy will affect people's ability to adjust status. So please take a look at that. This is really going to be the source of everything that we're going to be discussing today. So before we jump into these two pieces of guidance, we'd like to just give you all a background as to the significance of matter of ZRZC. So I'm going to hand things over to Jen to talk a little bit about that.
Thanks, Alyssa. Okay, so just kind of rewind back 2 years. You may remember in August, it was August 20th of 2020, USCIS adopted this AAO decision called matter of CRZC. And by doing so, it abruptly changed what had been several decades of USCIS policy. So starting on August 20th, USCIS no longer considered a TPS recipient who had entered without inspection, then traveled with advanced parole and returned. It no longer considered these people to be inspected and admitted or paroled, which is one of the requirements to adjust under 245A. Instead, USCIS said that under this 1991 law, abbreviated as MTINA, it's the Miscellaneous and Technical Immigration and Naturalization Act, that those TPS recipients were returning to the US as TPS recipients who had entered without inspection. So they were neither admitted or paroled. This CRZC policy applied only prospectively to travel that occurred after August 20th of 2020. For the past almost 2 years, any travel and return after that date would no longer overcome the person's original EWI, and it did not make these TPS recipients potentially eligible to adjust on the basis of a family petition or employment-based petition. So this was very bad news, and the outcome, for the past couple of years is that many TPS recipients who got advanced parole or could have gotten advanced parole and traveled, they lost their ability to use that authorized return to qualify for adjustment, so they could still travel, but they wouldn't be able to rely on this to help them become admitted or paroled for 245A purposes. So that's kind of where we were, but as Alyssa has already explained, on July 1st of this year, USCIS rescinded its designation of CRZC, and it issued this new policy about how it will handle and interpret travel by TPS recipients. So we're going to get into the weeds on this, but kind of the big highlights are first that USCIS is now issuing a new type of TPS travel document. It's called Form I-512T. So it's no longer going to issue advanced parole as it has been doing in the past. So you can still apply for a travel document. You still file the I-131 application. That hasn't changed, but you'll be getting this I-512T, this new type of TPS travel permission. And we're going to talk more at the end of the webinar about the application process for the document. The second highlight is that starting on July 1st of this year, TPS recipients who travel with prior authorization will be considered inspected and admitted once they lawfully return to the United States. And that's true even for TPS recipients who originally entered the US without inspection, which many of our TPS clients did. And as we've mentioned, being inspected and admitted under 245A can make certain TPS recipients eligible to adjust status in the United States, assuming, of course, that they have an approved I-130, a current priority date, that they meet the other 245A requirements. So before we get into more detail, we thought we would just kind of do a quick review of INA 245A and what it says about adjustment eligibility in case that's helpful to kind of set the stage. So 245A requires the applicant to be inspected and admitted or paroled. And this is the requirement that many TPS beneficiaries can't meet since they originally entered the US without inspection. So this is where the authorized travel can come in and help them meet this particular requirement. Second, there must be an immigrant visa immediately available. So maybe the person is an immediate relative, or if they're in a preference category, they must have a current priority date. Thirdly, the applicant cannot be inadmissible under any of the 212A grounds. If they are inadmissible, they need to be eligible for a waiver of inadmissibility, assuming that particular ground can be waived. You must warrant a favorable exercise of discretion, so that's a component. And then finally, the applicant cannot be restricted under INA section 245C. So 245C bars somebody who has ever worked without authorization or has failed to continuously maintain lawful status since entry. Now, there are certain folks who are exempt from 245C, So one big group is immediate relatives. So the spouse, parent, or unmarried adult child of a US citizen, sorry, unmarried child, not adult child. Also VAWA-based adjustment applicants are exempt. And then we're going to talk a little bit later about some employment-based applicants who might be eligible for an exception to the 245C bars. So we're going to walk through a couple hypos to just illustrate these points. But I'll just say, kind of remember that in addition to 245A, if you have a client that isn't going to qualify under 245A, there's also the possibility of adjusting under 245I for folks who are the beneficiary of a petition filed on or before April 30th, 2001. But at least kind of in the family-based context, if you can't adjust under 245A or 245I, you're left with consular processing, which can be problematic for many TPS clients in particular, who might trigger inadmissibility grounds that they can't overcome, on top of course, the inherent expense and inconvenience of leaving the United States to get your green card. So let's look at our client Daniela and whether she is eligible to adjust under 245A. So Daniela came to the United States as a tourist in 2019 and overstayed. She was approved for TPS in April and just married a US citizen. So our question to you is, if Daniela's US citizen spouse petitions for her and she applies for adjustment, is she eligible to adjust under 245A? So what do people think? We're starting with an easy question here, and you can jump in the chat box. I'm seeing unanimous yeses, and that's absolutely right. So she was inspected and admitted. She came in as a tourist. She's married to a citizen, so she's an immediate relative. So as long as she's not inadmissible, she deserves a positive exercise of discretion. She's going to be 245A eligible. And as we mentioned, because she's an immediate relative, those 245C bars do not apply to her. So it doesn't matter for her that she failed to maintain lawful status prior to getting TPS. And it wouldn't matter also if she had worked without authorization. Okay, so let's look at the next question. What if instead of being married to a citizen, she was actually married to an LPR? What do you think about that? Is she going to be adjustment eligible if she's married to an LPR? So I'm seeing a lot of no's in the chat box, and that's right. So she's no longer an immediate relative. She would be a preference relative, and preference relatives are not exempt from the 245C bars. So her B2 status would have lapsed before she got TPS this April. And so she's failed to continuously maintain lawful status since entry. And so 245C is going to prevent her from adjusting. All right, great job. We have two more. So we're going to keep the same facts as the original hypothetical, but let's say that Daniela entered the US without inspection. So she didn't come in as a tourist. She was iwi, but she's still an immediate relative. She's married to a US citizen. Can she adjust under 245A? What do you think? All right, no, everyone's saying no. And that's right, because she was not inspected and admitted or paroled, and that's going to disqualify her under 245A. But our final scenario, what if Daniela did still iwi in 2019, but she obtained travel permission and she went to Haiti and she just got back last week? Can she adjust under 245A? Everybody's saying yes. Yes, that's right. So under the new policy, when she came back in under authorized travel, she is now considered inspected and admitted, and she has overcome that original iwi. She's an immediate relative. She's been inspected and admitted. So as long as she's not inadmissible, as long as she meets the discretionary standard, she is now eligible to adjust under 245A. So that authorized travel and return has helped her qualify under the new policy. So I'll just mention that the vast majority of TPS recipients who will benefit from this new policy are immediate relatives who were originally EWE'd and then got TPS and traveled. This isn't going to help most preference category relatives. And that's because, you know, even if they can overcome that original entry without inspection by traveling, they're still going to have that 245C bar to contend with based on a failure to continuously maintain status. All right, so it's pretty clear, I think, that, you know, how this new policy applies to clients who travel moving forward. But I know that many folks have questions about clients who have already traveled and how this policy will or won't apply to them to potentially help them become adjustment eligible. So I'm going to pass it over to Alyssa now to talk to us about how this impacts people who traveled prior to July 1st of this year.
Okay, thank you, Jen. And we have had a number of questions about this already. So I know this is something that a lot of people want to know about. So the question is, does the new policy apply to people who traveled with advanced parole in the past prior to the announcement of this new policy? And the answer is that in most cases, yes, but it does depend. So let's break down how that works. If you're in the Fifth Circuit and you are a TPS recipient who first entered without inspection but has since traveled, this is pretty straightforward. All authorized entries after advanced parole travel, or what's now being referred to as authorized travel, but after you've returned with advanced parole, that will be considered an inspection and admission for purposes of 245A, regardless of when you traveled. So that would apply to people who traveled, you know, prior to July 1st, 2022, and that's only in the Fifth Circuit. So that's people who are residing in Alabama, Florida, Texas, Louisiana, Mississippi. For everyone else, if you reside outside of the Fifth Circuit, USCIS says that this is a case-by-case determination. So there's an evaluation process that has to be followed. First, USCIS will determine whether treating a prior entry as an admission rather than a parole or some other authorized entry, whether that's necessary for adjustment eligibility. So if it's clear that an admission is not needed in order for someone to become adjustment eligible, there's no need to apply the current policy. So someone typed in earlier with a question about a client who traveled with advanced parole prior to matter of ZRZC, so prior to August 20th, 2020. They were already paroled when they returned to the United States on their advanced parole. And so they meet the requirement of 245A, they've been inspected and paroled. And so it's not necessary to apply this new policy to that individual case. So that's partly why they're doing this case-by-case evaluation. And if it's clear that we don't need the new policy to be applied, they're not going to go through further evaluation, and that person can still be eligible for adjustment based on the prior policy. If it's clear that the current policy would be necessary in order for someone to become eligible for adjustment, in other words, they need that past travel to be considered an admission, USCIS will go through a 5-factor test to evaluate whether it's appropriate to apply the current policy retroactively. And this is something we're going to talk more about. And you'll find the details about this in the USCIS policy manual. But for now, I just want to outline what the decision-making procedure is going to look like. So I think the people I think we're getting a lot of questions about people who traveled in the ZRZC era. So these are the people who traveled between August 20th, 2020 and July 1st, 2022, when the policy changed. And so a lot of people have questions about whether this new policy can be retroactively applied in their case. So again, there could be some people who traveled prior to ZRZC and were paroled, where it might make a difference in their eligibility to have an admission versus a parole. Jen's going to talk about that a little in a little bit when we get into employment-based immigration 245K. But for most people who travel prior to ZRZC, it's not going to be necessary to do this evaluation. For those people who did travel during ZRZC, in which case they were not admitted or paroled when they returned, they're not going to be eligible for 245A adjustment unless their travel can be considered an admission. So this is where USCIS will need to take the further step of doing this analysis and weighing the reliance interest versus the potential harm if the current law is retroactively applied. So I would just say, well, from what we can tell so far, for most people who did travel during ZRZC, their eligibility for adjustment would seem to outweigh other factors. So USCIS has indicated in their guidance, they think it's most likely that people in that situation would have their past travel count as an admission retroactively. So let's just take a look at another visual that might help us understand this. I know there's a lot of different parts to this. So this flow chart might help us kind of visualize this a little bit better. So remember, in all cases, we're talking about TPS beneficiaries who last entered without inspection, or I'm sorry, they first entered without inspection. Before they obtained TPS, they are living outside of the Fifth Circuit, and they have either traveled or they're intending to travel with prior authorization. So there are three groups of people here. For the group on the left and the group on the right, it's fairly straightforward. So let's look at that first column on the left. That is for people who traveled with advanced parole prior to August 20th, 2020. So prior to matter of ZRZC. The first question that you will want to ask is the new policy needed in order for them to become eligible for 245A adjustment? In most cases, the answer is going to be no, because their prior travel, their prior reentry was likely to have been considered either a parole or admission for 245A purposes. So that means they would be eligible for 245A without the aid of this new policy. On the far right, we have the category of people who traveled on or after July 1st, 2022. So they're traveling on or after the issuance of the new policy. Again, very clear, the new policy applies, and upon return, they will have been inspected and admitted. And then so that leaves us with this middle category, which is a little bit more complicated. The people who traveled during that ZRZC era. And so to work through this, we would first ask, again, would it make a difference if they are considered admitted versus applying the prior policy that was in place versus applying ZRZC? And the answer would be yes, without having their last entry counted as an admission, they're not going to be able to be eligible for 245A, since upon their return during that ZRZC era, they would have been neither admitted or paroled. So then the next step after you determine that is to apply a 5-factor test that is meant to balance various considerations and determine whether or not USCIS should apply the new policy retroactively, and assuming that they determine that it is more favorable to apply the new policy, they should do that. So let's take a look at what these 5 factors are and what USCIS is going to consider. So this 5-factor test, you'll find more about this in the updated USCIS policy manual guidance. I'm not going to read through each factor here. I will say that the guidance does provide a little bit of explanation to each of these factors, and it indicates that factors 1, 2, and 5 tend to be consistent across most cases. In other words, factors 1 and 2 tend to weigh against retroactive application, and factor number 5 tends to weigh in favor of retroactive application, and that will tend to be true across all cases. So the main issues that USCIS indicates they're going to focus on would be factors 3 and 5. So since that's our particular focus, let's look at those. Factor number 3 says the extent to which the adjustment of status applicant relied on the former rule. And number 4 is the burden, if any, that retroactive application of the policy would impose on the adjustment applicant. In most cases where the applicant meets all other eligibility requirements for adjustment, the change in policy or applying the new policy doesn't necessarily create a significant burden for the applicant and is most likely going to be favorable. And so USCIS is indicating that in most situations, it will be appropriate to apply the new policy and to consider that past travel to be an admission. Now, it's possible that the TPS beneficiary could have relied on being paroled into the United States rather than being inspected and admitted. And so if that's the case, then the officer would weigh any negative impact against other factors that would weigh in favor of applying the new policy. So again, it's a determination that's made on a case-by-case basis. So at this stage, it's not clear what sort of situation would lead USCIS to determine that an applicant had a significant reliance interest on being paroled rather than being admitted, and in which situations that reliance interest would outweigh the interest in having their last entry considered an admission. So that's something that we're going to be looking out for, and we'll be waiting to see how this is actually implemented as time goes on. Let's just take a look at an example to kind of help us see how this could work in practice. So we have Samuel, who lives in Washington. He initially entered the US without inspection in 1998 and was granted TPS in 2001. He traveled and returned with advanced parole on December 22nd, 2021. His US citizen son wants to file an I-130 petition for him. And he wants to know, will the new policy help him to adjust status? So let's just think through all the steps here. The first question that we want to ask, since it's clear he's outside of the Fifth Circuit, we want to know, does the new policy make a difference to his ability to adjust? So you can type into the chat box if you want to weigh in. I think, and people are saying, yes, it does make a difference, right? Because he initially traveled, he entered without inspection. He last traveled and returned with advanced parole in 2021. That's when matter of ZRZC was firmly in place. So when he returned, he was neither admitted or paroled. So if he wants to adjust under 245A, he's going to need to have that last entry counted as an admission. So it would make a difference in this case. The next question is, if the new policy is applied retroactively and he's considered admitted, we would have to look at the various 5 factors to see whether the balance of interest makes it more favorable for him to be considered admitted and to have the current policy retroactively applied. So again, the focus is typically going to be on his potential reliance on the former rule, and any kind of burden that might be imposed on him if the policy was applied retroactively. And assuming he's otherwise eligible for adjustment, there's no apparent inadmissibility issues, most likely the factors would weigh in favor of retroactively deeming his last entry as an inspection and admission to allow him to adjust status. And I'll just mention, we'll talk about this more in a second, but since people have asked about matter of Arabelli and Yarabelli, there is that is still in place, and that hasn't changed with the new guidance. So although he has accrued unlawful presence before he departed with advanced parole, his departure did not trigger inadmissibility under 212A9B. So that's not something that he needs to worry about in this case. All right, so I mentioned that there are some situations in which it might not necessarily be favorable to have the current policy applied retroactively, and some people may not want to have an admission, or some people may not want to have a parole. It might make a difference in certain situations. So Jen, can you tell us more about that and what some of those considerations are?
Yes, sorry, it took me a minute to unmute myself there. So, right, as Alyssa just said, there are some situations where it's going to make a difference whether the person is deemed admitted or whether they're deemed paroled. There may be situations where a client needs an admission and not a parole. There might be a case where they want to have a parole and not an admission. So a couple of scenarios where this distinction might make a difference that we wanted to highlight. The first one is there may be TPS holders who are filing employment-based adjustments who need their past travel to be an admission in order to qualify to adjust. So we talked earlier about the 245C bars, and they do apply to employment-based applicants. These folks are not exempt from 245C, just like family-based preference relatives are not exempt. But for employment-based applicants, they can benefit from something called INA Section 245K, and that can help them overcome 245C as long as they are present in the United States pursuant to a lawful admission and have not failed to maintain lawful status for more than 180 days subsequent to that admission. So what this means is that there may be employment-based adjustment applicants who, prior to CRZC, were paroled after traveling abroad, and that parole prevents them from adjusting status. If that return was instead considered an admission, then they would be able to meet the 245K exception and be eligible to adjust. So this is something that a USCIS adjudicator will consider when they do the retroactive determination. And if there's an employment-based applicant who needs an admission to rely on 245K to adjust, then this would weigh heavily in favor of that interpretation in that case-by-case assessment. And it's something that you might want to point out. So another kind of scenario to be mindful of where the parole versus admission distinction could be important relates to inadmissibility. So we know that somebody who has been admitted into the US is subject to the grounds of deportability if they're placed in removal proceedings. Someone who has been paroled would be subject to the grounds of inadmissibility. So there may be TPS recipients who relied on prior USCIS policy to avoid triggering certain inadmissibility grounds. Also, for clients who want to travel with a TPS travel document in the future, when they return and present themselves for inspection and admission, they could trigger 212A9A if they've departed with an outstanding removal order. And in order to adjust status during the next 10 years, they would need an I-212 waiver. Similarly, someone who's seeking admission who had an in absentia order could trigger inadmissibility for 5 years under 212A6B. And for that ground, there is no waiver for purposes of adjusting status. So just flagging these issues, we're going to talk more about them, but these are issues in admissibility that you're going to need to think through with each client, depending on the specific facts of their case. And then also related to inadmissibility, Alyssa just mentioned this, but there has been some confusion about the 3 and 10-year unlawful presence bars under 212A9B, and whether this new USCIS policy changes how the agency views a departure with advanced parole or with a new TPS travel document after someone's accrued certain periods of unlawful presence. And both the memo as well as the policy manual guidance are clear that USCIS will continue to apply the holding of matter of Arabelli. That's a 2012 BIA case that says that leaving with advanced travel authorization does not count as a, quote, departure for purposes of triggering the 3 or 10-year bar. So just to kind of show you how this might look, We have Lucas, who entered the United States without inspection in 1998. In 2005, he obtained TPS. He's married to a US citizen. He wants to know, he wants to apply for a travel document and wants to know whether he and his spouse can file a one-step after he returns. So what do you think? If he gets a new TPS travel document, he leaves and he re-enters, is he going to be able to adjust? Well, we know that yes, under the new policy, that return will be considered an inspection and admission. So he'll be able to overcome that 1998 EWI. And then in terms of inadmissibility, he would have accrued, 7 years of unlawful presence between his EWI and getting TPS. So we're thinking, is he going to trigger the 10-year bar when he departs? And the answer is no. He's not going to trigger that ground of inadmissibility under the matter of Arabelli case, because somebody who travels with advance parole or with a TPS travel document is not considered to have made a departure within the meaning of 212A9B. So USCIS policy has not changed on that. Somebody who has relied on Arabelli in the past is still protected. Somebody who's traveling in the future should also still be protected. Okay. So another topic, we've been getting questions about this in the chat box, and we wanted to cover, this deals with TPS recipients who travel with a prior unexecuted removal order. And I'll just kind of say that the impact of the new USCIS policy on clients with removal orders is not, I guess, crystal clear. It's not something that we have extensive or explicit USCIS guidance on. So we're going to just share what we know at this point. One thing that is clear is that the rescission of CRZC does not impact or change USCIS's December 20th, 2019 policy. That policy was that a TPS recipient with an outstanding removal order who departs and returns with advance parole does not execute that removal order. And since that TPS beneficiary remains subject to the removal order upon their return, it is EOIR, the Executive Office for Immigration Review, that has jurisdiction over a subsequent adjustment application, because basically that person is still considered to be subject to removal proceedings, unless those proceedings are reopened and dismissed. If they are reopened and dismissed, then USCIS would have jurisdiction over an adjustment application. And we know that there are typically strict time bars to filing a motion to reopen. But under this recent settlement in a lawsuit called Carreson versus Jadot, the ICE Office of the Principal Legal Advisor will agree to join a motion to reopen and dismiss for certain TPS beneficiaries. And Alyssa is going to talk more in a moment about who exactly qualifies for this. Last thing I want to say, another reason that we care about whether or not travel executes an outstanding order, aside from the question of jurisdiction over the adjustment, is because if it was executed and the person is trying to adjust within 10 years of that departure, they might need to file an I-212 waiver to overcome inadmissibility under 212A9A. So it seems that we have this kind of scenario where USCIS is saying the departure doesn't execute the order, but the departure does trigger 212A9A and also 212A6B for departing after an in absentia order. So we're going to talk a little more about this and look at a couple of hypos. But I'm going to first pass it on to Alyssa to talk to us more about the Carreson settlement.
Okay, so I just wanted to review this briefly so people know where to find more information about this when their clients are in this situation. But as Jen said, this is a settlement that was reached March 21st of this year, and USCIS, I'm sorry, ICE OPLA has agreed to join motions to reopen and dismiss removal proceedings for certain TPS recipients so that their adjustment of status applications can be filed with USCIS. So you see the eligibility criteria here. To qualify for this, you have to currently possess TPS, have a removal, deportation, or exclusion order, must have traveled on advanced parole or authorized travel since the order was issued, and you have to otherwise be prima facie eligible to file for adjustment of status with USCIS. So that would include people who have a pending or approved IR petition, immediate relative petition, people who have been admitted or paroled by virtue of their past travel, and also those who are, of course, admissible or eligible for a waiver of inadmissibility. And I'll just mention that this settlement will remain in effect until at least January 19th, 2025. After that date, there's no guarantee about whether this prosecutorial discretion option is going to be extended. It's, I think, largely dependent on who is going to be in office at that time. So we are encouraging people to move through this process as soon as possible and complete that request for reopening and dismissing removal orders. Work through those adjustment applications as quickly as you can, to the extent that you're able, so that people can take advantage of this. If we go to the next slide, we just have a few resources here that you can check out if you'd like more information. You can easily find the settlement agreement online, and that includes a template joint motion to reopen and motion to dismiss. That's available on the Caressin website, which you see there. I believe you can also find that on the ICE OPLA website, along with additional guidance. USCIS has guidance about this also. So we would encourage you, if you have questions about how this works, what the procedures are for applying for adjustment once the removal order has been reopened and dismissed, and I would encourage you to take a look at these websites. And now we're going to take a look at a couple of examples dealing with some of these removal issues that Jen was talking about. So Rosario is a TPS recipient who first came to the US without any documents. Prior to receiving TPS, she was placed in removal proceedings and given voluntary departure in 2009. However, she never left. She now would like to travel abroad to visit her aging parents, and Rosario's spouse just naturalized. So can authorized travel help Rosario to become an LPR, and what should you consider before advising her? So if you have thoughts about that, you can put that into the chat box. So let's review what we have here. Rosario is married to a US citizen, but she entered without inspection. So at this point, she's not eligible to adjust under 245A without an admission. And she's also never departed after she was given voluntary departure. So that voluntary departure order converted to a final removal order. So we know, and people have answered this in the chat, so thank you. We know that traveling could help her become eligible for adjustment, since she would then have an admission, but then we are contending with this issue with her removal order. So this brings up a specific ground, 212A9A2. I am going to put the statutory language into the chat box so you can take a look at it for yourself if you need to refresh your memory. But this ground of inadmissibility applies when a non-citizen departs the US while an order of removal is outstanding, and then they seek admission within 10 years of that departure or removal. So pay attention to that statutory language. It can be triggered if you seek admission within 10 years of departure or removal. So USCIS has indicated in their policy guidance that departure could trigger inadmissibility. You can see that clearly from the statute. And since the TPS recipient is departing and upon return, they're now seeking admission. They're not seeking parole, but they're seeking admission. 212A9A is an issue. So even though it's very clear that her travel has not executed the removal order according to USCIS policy, it is considered a departure that triggers this particular ground of inadmissibility. So until we get any additional clarification on this, I would assume in Rosario's case, she does trigger 212A9A. I would say it's likely okay to travel with the prior removal order. Re-entry is discretionary. She's going to submit herself to inspection by a CBP officer. So ultimately, they do have the discretion to deny someone entry, but it won't necessarily prevent her from being able to re-enter. And we have not seen this really be a problem at the border, at the port of entry. Typically, people who travel with advanced parole who are TPS recipients, usually they are able to re-enter without any issues despite having a removal order. So I would suggest that she go ahead and travel on advanced parole. Once she returns and she's admitted, she could then request that this removal order is reopened and terminated through the Caressent settlement. Assuming that it is reopened and dismissed, she could then file her application for adjustment with USCIS, and she could include a nunc-pro-tunc I-212 to overcome this 212A9A ground of inadmissibility. The I-212 is something that was typically required prior to the change in policy. So this is, I don't think it's anything too new. It's what people were filing in the past. They're usually fairly easy to get approved. And so she can likely overcome this ground of inadmissibility. And I'll note this, Jen mentioned it, but just because I know we get a lot of questions about it. Even though this is considered departure for purposes of 212A9A, it's not considered a departure for purposes of 212A9B, the 3 and 10-year bar for unlawful presence. And that is because of this BIA decision matter of Arabelli and Yarabelli. That holding is specific to 212A9B. And so that's why she's not inadmissible for 212A9B, and yet she still has a departure and is inadmissible for purposes of 212A9A. One other thing to watch out for is INA section 240B-D, which says that someone is ineligible for adjustment for 10 years following a failure to depart within the voluntary departure period. So it doesn't apply in this case because it's been more than 10 years since Rosario departed, so she's not barred from adjustment. But I just want to mention that so that you're aware it could be an issue for other clients who are seeking adjustment within 10 years of failing to depart under their voluntary departure order. Okay, so let's take a look at another example. Same facts with a twist. So Rosario is a TPS recipient who first came to the US without inspection, but instead of receiving voluntary departure, she failed to attend her removal hearing and was given an in absentia order in 2009. So would this change your advice? Let's go to the chat box and see. I think some people are saying yes. This does bring up another possibility of inadmissibility, and that's under 212A6B. Again, I'm going to go into the chat box and put in the statutory provision in case you want to take a look at that. 212A6B says that any non-citizen who, without reasonable cause, fails or refuses to attend removal proceedings and who seeks admission to the US within 5 years of their subsequent departure or removal is inadmissible. And unlike the earlier ground that we talked about, 212A9A, there's no waiver for this. Right, and Gabby pointed that out, thank you. So that's exactly right. Let's go back to kind of the beginning of our analysis. If she travels with authorization now, is that a departure? Is she executing the removal order? We talked about this. It is a departure for purposes of inadmissibility under 212A6B. For purposes of 212A9B, it is not a departure because of matter of Arabelli. So this is something that maybe we can watch out for. There is a potential argument that the reasoning that is applied in Arabelli should apply to these other grounds of inadmissibility. So maybe that's something that could be challenged in the future, but at this point, we're going to assume that Rosario has triggered a ground of inadmissibility. She can still travel with advanced parole. Upon re-entry, she would be considered inspected and admitted, so that will help her to adjust under 245A. And from there, we would follow some sort of similar procedure. You would want to have her reopen the removal order, have that dismissed under the caress and settlement. It's unclear, I think, whether having that in absentia order is going to make it any harder for her to get that removal order reopened and dismissed, because under the terms of the settlement, eligibility includes that the person has to be prima facie eligible for adjustment. They have to be admissible, and here she's not admissible. So that's a potential issue. There is an argument, however, if there is an argument that she had reasonable cause for failure to attend her removal hearings, that's one potential way she can argue that she is not in fact inadmissible. So if there there's reasonable cause for not attending, let's say maybe she didn't get notice of her hearing, she was hospitalized at the time of hearing, whatever the case may be, that's one way of arguing that this ground shouldn't apply. But again, there is no waiver for this particular ground. Assuming that she does get this reopened, she can file for adjustment with USCIS, again, making those arguments against inadmissibility, or perhaps a safer alternative if she does not have reasonable cause for her failure to attend her hearings. She could just wait for 5 years after travel before she applies for adjustment, just to try and avoid that inadmissibility bar. So a couple of ways that she could potentially handle that. One other thing to watch out for, again, there's another issue here, 240B7, INA 240B7, that's a 10-year bar to adjustment after entry of a final removal order in absentia, after receiving proper notice of hearing, unless the failure to attend is due to exceptional circumstances. So another thing to watch out for if you have a client who has an in absentia order and is hoping to apply for adjustment of status, there is a 10-year bar to look out for. Okay, so let's wrap up this section by just reviewing what we covered. I'm going to turn things back over to Jen.
Thanks. So this is just kind of a summary of some of the issues that Alyssa just walked through in the last couple of hypos. So I'm not going to spend time reading through these or going over these, but they're here for your reference. We wanted to spend just a few minutes talking about applying for travel authorization. So the form to seek travel authorization is still the I-131. At least for now, there is no modified or updated form or instructions, no TPS specific I-131. The I-131 can be filed with the I-821 TPS application, or it can be filed separately with the I-797 notice that shows either that your 821 is pending or has been approved. The fee is the same. Just a note, if you are wanting to file the I-131 concurrently with the 821, you won't be able to file online. You'll have to mail paper applications because at this point, at least 131s can't be filed online. Maybe that will change. So TPS recipients in the future should not, as we've said, should not be getting advanced parole. They should be issued the new I-512T document. TPS applicants who want to travel, by applicant, we mean somebody who has a pending TPS application that hasn't been approved yet. Those folks, USCIS says on the website, will still be issued advanced parole. If your client had already filed the I-131 and that application was pending on July 1st when this policy change was announced, they don't need to file a new application. Our understanding is that USCIS will issue the new travel document to those folks. But either way, they're going to get a travel document and upon traveling should be considered inspected and admitted. And then TPS clients who already have a valid advance parole document from before July 1st should still be able to use that advance parole through its current expiration date. So they don't need to go file a new I-131 to get the new kind of document. If they already have a valid advance parole, they can still use that valid document. So we have 5 minutes left. Just kind of in closing, we wanted to recap the major components of the new policy. These are the top takeaways. First of all, TPS recipients can still travel. It won't be, USCIS won't be using advance parole as the mechanism to authorize that travel. It will issue the I-512 TPS authorization travel. But as we've reviewed, the application process for now remains the same. Second takeaway, TPS recipients who travel anytime after July 1st, regardless of whether they're using a new travel document or a prior but still valid advance parole, they will be considered inspected and admitted upon their return to the United States. And for certain clients, this might make them eligible to adjust under 245A when they would not have been eligible before because they first entered the US without inspection. Third takeaway, for TPS folks who traveled during the CRZC era, before the new policy went into effect, if they need their return to be considered an admission in order to be eligible to adjust, USCIS can apply the new policy to them retroactively using the 5-factor test that we reviewed. And USCIS has acknowledged that in most situations, the scales will tip in favor of deeming the person's return to be an admission. Now, if you have an adjustment case where you need a retroactive determination that the client has been admitted, you might want to flag this in the adjustment application. So you can certainly refer to the new USCIS memo, to the new policy manual guidance. You can mention the 5-factor retroactivity test in your cover letter. We've gotten some questions about, well, do I need to submit evidence of each of the 5 factors? And, you know, we don't know, this is a new process. So we're going to certainly be monitoring how these cases are being adjudicated, how USCIS is applying these factors, what kind of RFEs they're issuing, what any denials might look like. So this is a work in progress, and it's really going to be up to individual practitioners to decide how much they want to, you know, spend on this. But, you know, at a minimum, I would say it's worth mentioning it, pointing it out. You know, you can include a copy of the guidance with the application. And also, you know, let us know if you're getting decisions or RFEs, what you're seeing, so that we can continue to advocate with the agency on this. A few more takeaways. So for clients who want to travel, make sure you screen them, that you're looking into any possible inadmissibility grounds that could be triggered by leaving the US, particularly as we've highlighted related to prior removal orders. So this could pose a problem down the road when they apply to adjust status. So look out for 212A9A departing after a removal order, also 212A6B departing after an in absentia order. You want to make sure that a client's decision to travel is not going to trigger new inadmissibility grounds that they will not be able to waive or overcome, or that will prevent them from adjusting status in the future. It does remain USCIS policy that authorized travel by a TPS recipient with an outstanding removal order does not execute that order. So that 2019 policy has not changed. However, for clients who want to adjust but remain under the jurisdiction of the immigration judge based on that unexecuted order, remember the process for getting ICE to join in a motion to reopen and dismiss so that the client can apply to adjust with USCIS. And then finally, we have a link here to our updated practice advisory on adjustment options for TPS beneficiaries. So please feel free to take a look at that resource. All right. And I think we're right on time. I know we've gotten a lot of questions. We've tried to answer them as we go today, but we weren't able to answer everybody. So we will be reviewing your questions and trying to, look into any issues that we don't know the answers to yet and share that in future webinars, future clinic mailings, and updates to our TPS advisory that we linked to in the last slide. So thank you so much to all of you for being such a great audience. Thank you so much, Alyssa, for being my partner today. We hope you all have a great weekend.
Enjoy your weekend. Thank you.